is because throughout history, tyrants have made the offer of what we might call a devil's bargain to those they would tyrannize. In exchange for rights, for liberty, subjects are told they can enjoy peace and safety. One of the most important rights that free men have to defend is the right to bear arms in defense of themselves, their families, their rights, their property, their liberty. We're being offered that devil's bargain today, as people say that in exchange for surrendering our God-given right to keep and bear arms, we can enjoy peace and safety guaranteed by an all-powerful state. And that's a bad deal any way you look at it. I think one of the best expositions of the point of view that we could call the peace and safety argument is offered by Harold S. Hurd, who is a retired justice of the Kansas Supreme Court, and he is distinguished jurist in residence at the Washburn University School of Law. In a 1997 Law Journal article, Judge Hurd had the following things to say regarding those of us who cling to the increasingly unfashionable view that free men and women have to have the right to keep and bear arms in their own defense. I quote now from Judge Hurd's Law Review article, quote, "It is time for America to act responsibly and stop the proliferation of arms. The more guns in private hands, the more fear exists with an increasing demand for more guns. The irrefutable facts are that gun-related violence is running rampant in this country. That is sufficient impetus to attempt to control guns in any way needed to halt the carnage. The statistics of firearms violence in America are overwhelming, and the government clearly has the power and authority to do something. Firearms, particularly handguns, are dangerous instrumentalities which government has a duty to regulate for the protection of the health, safety, and welfare of the public. It is time for the debate to end. It is now time for government to discharge its duty and furnish public security." Close quote. Now, how does Judge Hurd treat those of us who might disagree with that worldview? Well, according to him, we are, quote, "extremists who refuse to accept majority rule, even on social and economic issues where it clearly applies, and who are united by the belief that the Second Amendment to the United States Constitution guarantees an individual right to bear arms. This right to bear arms is essential to extremists because they feel that the only way to protect their rights is by arming themselves. They never mention the rule of law except to assert it in their efforts to oppose gun control. They are convinced killing solves problems." Close quote. Now, Judge Hurd's perspective, which I'm powerfully tempted to refer to as herd poisoning in recognition of Orwell's term for statist propaganda, is fact-starved and falsehood obese. It's also quite typical of what passes for scholarship in legal circles these days regarding the right to keep and bear arms. It also has some interesting historical resonances and parallels, both in ancient history and in more contemporary history. I think that a 1777 proposal that was written by William Knox, who was the Undersecretary of State for the British Colonial Office, that proposal was entitled, "What is Fit to be Done with America?" I think that's sort of a first draft for the worldview that Judge Hurd represents. Here is an excerpt, a brief excerpt from the 1777 proposal from Secretary Knox, and I think that it is quite an interesting parallel to Judge Hurd's comments. Quote, "The militia law should be repealed and not suffered to be reenacted, and the arms of the people should be taken away, and every piece of ordnance removed into the king's stores. The subjects will have but little need of such things for the future, as the king's troops, ships, and forts will be sufficient to protect them from any danger." Close quote. That is, any danger except that which is represented, individual freedom, by the king's army. It will be recalled that our war for independence began on April 19th of 1775 when militiamen in Lexington, Massachusetts refused to surrender their arms to the British Redcoats, or if you will, to the peacekeepers of the time. 3 days later, after the opening skirmish of our war for independence, British General Thomas Gage ordered civic officials in Boston to conduct what is now commonly called a gun turn-in program. More contemporary expression for this is micro-disarmament. That's the expression that the United Nations likes to use, and we'll refer to that a little bit later. Armed men in Boston, patriots, were invited to surrender their weapons to civic authorities into the temporary custody of civic authorities they were promised in exchange for amnesty, and more than 3,000 weapons were turned in pursuant to this offer. After the weapons were turned in, General Gage and his men informed those who would surrender their arms that the weapons surrender was now to be continued indefinitely, In other words, he went back on his word. And on July 6th of that year, July 6th of 1775, the Continental Congress adopted a document written by Thomas Jefferson and John Dickinson entitled The Declaration of Causes of Taking Up Arms. And in that list of grievances, General Gage's disarmament of the Bostonian patriots through deception was very prominently mentioned as one of the reasons why America had no choice but to withdraw from the British Empire. So we can see that in the worldview of the extremists who presided over our war for independence and later on went on to create our Constitution, in their worldview, it was understood that free men cannot be debarred the use of weapons in defense of their liberties. A population of free, armed people can be governed, but it is difficult to rule. For those who would be free, the right of armed self-defense is indispensable. For those who would rule, it is a nearly insurmountable obstacle to their ambitions. And I think that that's a necessary understanding as we continue our review of what's going on with respect to civilian disarmament, both nationally and internationally. Now, from time to time, a shaft of candor will penetrate the murk of misinformation that conceals the true intentions of our would-be rulers. There's a fellow by the name of Gregory King who was a spokesman for the Justice Department under Bill Clinton and Janet Reno, and he was caught in a moment of candor of that sort in 1998 as he tried to explain why the much vaunted Brady Law resulted in a negligible number of criminal prosecutions. In 1999, for instance, only 29 people were convicted of lying about criminal records as they went about trying to purchase a firearm. Now, speaking on behalf of the Clinton regime, Gregory King had the following explanation. He explained that the purpose of the Brady Law was, quote, to keep people from getting guns, not to increase federal prosecutions, close quote. Now, the Brady Law has been deemed an indispensable public safety measure that should have a dampening effect on murder and suicide. The American Medical Association, however, in a study released in early August of the year 2000, disclosed that the Brady Act had no measurable impact on murder and suicide rates, and a modest reduction was visible as a result of the Brady Act on the number of people 55 and older who had used handguns as a suicide method of choice. That is not to say, however, that the Brady Act has had no measurable impact on the subject of crime. To borrow from the language of the medical profession, if crime is to be considered a disease, then the Brady Law and other types of civilian disarmament measures could be considered an iatrogenic treatment, that is to say, a treatment that makes the affliction even worse. There is a scholar by the name of John Lott of Yale University, the Yale University Law School, who is the nation's foremost authority on the relationship between firearms and violent crime. And according to Professor Lott, one direct effect of the Brady Law has been to leave women particularly vulnerable to rape and other forms of violent assault. And Professor Lott has documented a correlation between the enactment of the Brady Law and a 3.6% increase in rapes and a 3% increase in aggravated assault against women. In brief, the Brady Law has been a staggering failure as both a crime control measure and as a public safety measure. But once again, as the Clinton administration admitted through Gregory King, neither crime reduction nor public safety was the objective of the Brady Law. Civilian disarmament was the objective of that measure. I think it would be worthwhile at this point to review briefly some of the history and some of the philosophy that undergird the American understanding of the right to keep and bear arms. The right to own weapons and to use them peacefully if possible, violently if it is tragically necessary to do so, in defense of one's person, property, and liberty, does not depend upon the Second Amendment to the Constitution. And the abolition of the Second Amendment, however unwise that would be, would not give the central government the authority to take our guns away, because that power was not delegated to the central government. The right to keep and bear arms, like the other rights mentioned and protected in the Bill of Rights, is a natural or God-given right. And it is a fundamental right which distinguishes freemen from feudal serfs and citizens from slaves. It is in fact a duty of those who would be free to defend and exercise that right. By acknowledging the right of the people to keep and bear arms, the framers of the Bill of Rights explicitly recognized a critical fact about the nature of our constitutional republic. Our government, almost uniquely in history, does not assume that the state has a monopoly on the legitimate use of force, and that government derives its just, limited, and irrevocable powers from the consent of the governed. It does not confer limited and revocable rights upon its subjects. If the central government can monopolize the legitimate use of force, it stands to reason that it can and will absorb and abolish all other liberties as well. This has happened repeatedly in history, particularly in modern history. Invoking the desire for peace and safety, governments have disarmed their subjects only to visit them with sudden destruction of their lives and liberties. In many cases, visiting upon their hapless, abject populations the mass liquidation of those who are unsuitable for assimilation into the new order. In protecting the right of individuals to keep and bear arms, the framers of the Constitution drew upon, and in some ways significantly expanded, an ancient Anglo-Saxon concept of individual liberty. I want to review just a few examples of some of the thinkers throughout Anglo-Saxon history who have identified the intimate relationship between the right to keep and bear arms and limited government and individual freedom. Sir Walter Raleigh is an individual whose spurious trial for treason and whose unjust execution led to some significant reforms in Anglo-Saxon jurisprudence with respect to due process. One of the things that Sir Walter Raleigh warned in his writings was that the first goal of any would-be tyrant is, quote, to unarm his people of weapons, money, and all means whereby they may resist his power. British essayists John Trenchard and Thomas Gordon wrote the immensely popular and very influential essays that were published as political tracts called Cato's Letters. They were made available in the 1720s. They were very popular in Britain and throughout the colonies. They had a great deal of influence on the thinking of our founding fathers. In Cato's Letters, Trenchard and Gordon warned, quote, he that is armed is always the master of the purse of him that is unarmed. And Cato's Letters also had the following observation, which influenced the thinking of George Washington, among others, among our founding fathers. Power is like fire. It warms, scorches, or destroys according as it is watched, provoked, or increased. And they understood that the right to keep and bear arms was a very important check rein on the potentially destructive nature of government power. The exercise of despotic power, according to Trenchard and Gordon, is the unrelenting war of an armed tyrant upon his unarmed subjects. In the 1770s, as America was heading toward independence and the crisis between the Crown and the colonies grew to a crescendo, English essayist James Berg declared, and I quote, no kingdom can be secured against tyranny otherwise than by arming the people. The possession of arms is the distinction between a freeman and a slave. Now, he was not the first British essayist of liberty to make that connection, to make that distinction, and to say that the possession of arms is what distinguishes a freeman from a slave. Scottish Whig essayist Andrew Fletcher, who wrote decades before James Berg, referred to arms in the hands of freemen as, and I quote, the only true badges of liberty, close quote. Fletcher was the author of an essay entitled A Discourse on Government with Relation to Militias, and that had a very obvious impact on the American founders, particularly the framers of the Second Amendment. They used the term well-regulated militias to describe the people independent of central government authority. That's an expression that's to be found in Andrew Fletcher's writing on militias. The purpose of militias of that sort, meaning the body of the population with the right to keep and bear arms protected in law, the purpose of such militias was to keep the people, quote, free from the fears of invasion from abroad as well as from the danger of slavery at home. The possession of arms is the distinction between a freeman and a slave, continued Fletcher. He who has nothing and belongs to another must be defended by another and needs no arms. But he who thinks he is his own master and has anything he may call his own ought to have arms to defend himself and what he possesses, or else he lives precariously and at discretion.